Have you ever booked a flat, paid lakhs of rupees, and then the builder goes bankrupt? What happens to your money then? Are you a home buyer or a creditor in the eyes of law? Well, Supreme Court just gave a major ruling that clears up all the confusion. And this could change how thousands of home buyers recover their money when a real estate company goes bankrupt. Hi, this is Ayantika, your legal faculty here at CLATapult. And in today's video, we will break down the case Mansi Brar Fernandez versus Shubha Sharma 2025 case, one of the most important insolvency judgment of the year. The Insolvency and Bankruptcy Code or IBC was brought in 2016 to help companies resolve their debts quickly, either by restructuring or selling of assets to pay the creditors. Now, in 2018, the law was amended to say that the home buyers, that is, the people who have invested in under construction project, would also be treated as a financial creditor. That means that they can file for insolvency against a builder if the project is delayed or abandoned. Sounds fair, right? But there's a problem. Some people started misusing it. They were not genuine home buyers. These people were speculators. That is, people who had invested only to make a profit and not to live in the flat. When the project got delayed, they rushed to file insolvency cases just to pressure the builders to pay them back. So the question became, how do we tell the difference between a genuine home buyer and a speculative investor? That is exactly what this case was about. In this case, a home buyer, Mansi Brar Fernandez, had booked a flat in a project and later filed an insolvency petition against the builder, that is Shubha Sharma, claiming that the builder had defaulted. But the builder argued that Mansi was not a genuine home buyer and that this was a speculative transaction. He also argued that she had bought the flat just wanting to resell it in future for profit. So the main issue before the Supreme Court was, can someone who has invested in real estate project purely for profit use the IBC to declare the builder insolvent? The Supreme Court looked at the intent behind the IBC. It was meant to resolve insolvency and not to be used as a weapon for recovery of money or blackmail. The judges stated that IBC is not a debt recovery tool. It is for genuine financial distress and not speculative gains. So the court made a few key points. First, not every home buyer is a financial creditor. The buyer must prove the genuine intent to purchase a home and not just to make money from appreciation. Second, speculative claims must be curbed. If the buyer's agreement, timing, or conduct shows that it was a profit-oriented investment, the case can be dismissed. And thirdly, IBC cannot replace civil or consumer remedies. The court reminded that there are other forums like RERA or consumer courts for individual grievances. By saying this, court protected the real home buyers who are the victims of delay and fraud, while preventing misuse of insolvency laws by opportunistic investors. This case is being called a milestone in insolvency jurisprudence. Why? Because it gives a clarity as to who can really file a case under IBC. It protects genuine home buyers by ensuring that their cases are taken more seriously, and it saves the builders and developers being dragged into insolvency unnecessarily. And in the bigger picture, it balances fairness and equity in India's real estate and insolvency ecosystem. Thank you and see you in the next video.